Welcome to another event of the King's Forum on International Dispute Resolution. We are putting up a lecture series with regular events. The next one will be on November 26th of the demise of the SADC Tribunal. And then in December we'll have an event with a judge from the International Tribunal for the Law of the Sea. If you're interested in those fields, today we have a very special event on international criminal law, international justice and practice, case studies in conflict and controversy. And we're extremely proud to have two of the most outstanding practitioners. If you read through their resumes, it's quite impressive. All of the cases that you will have read in law school in the field, you will find in there. Two of the best practitioners in the field speaking about their experience. Both of them Queen's Counsel, Karim and Rodney Dixon. I don't want to take up too much time with the introduction because I'm too curious about the lecture. You will have read a lot about international criminal law, a lot of news stories recently about South Africa and South Africa's reaction to the International Criminal Court, a lot of criticism in African countries, and I'm sure today we will get an inside view on how the system works, and in particular, whether it works.
Ladies and gentlemen, thank you so much for making the time to come to this talk this afternoon. I'm actually really gratified that so many members have come to listen, because I understand there's a large strike going on, a student strike in another part of London. And then I thought to myself, when I was at King's in 1988, 89, I remember that the only college that didn't strike was King's College. The students came in. So maybe that's the reason for the presence of some people today. The title of the discussion, of course, is Case Studies in Conflict and Controversy. And in all the gamut of international law, I think perhaps nothing arouses quite as much controversy as the role of international criminal justice. It is said either to be the panacea for all ills, a solution to a myriad of problems. Others, those that are detractors, say it is nothing other than neo-colonialism wrapped up in packaging that makes it more palatable for consumption in the 21st century. The reality, in our view, is neither of those two scenarios represents the actuality. One thing is certain, that the international legal order is a matter of constant debate. The ICC, of course, came into force in 2002. It's its teenage years, troublesome teens. It came into force in 2002. And in its body, it developed a very special relationship with the United Nations. Now, the United Nations itself is 70 years old. And there may be those that are saying it should be put into retirement, or it should be in desperate need of cosmetic surgery or organ transplantation. But one thing we will touch upon is that the relationship between the ICC and the United Nations is a matter for very legitimate discussion and debate. Now, I'm going to discuss in the next few minutes principally three situations, two which have been referred to the court by the United Nations Security Council, namely Libya and Sudan, and one, the case of Kenya, that was the first use by the prosecutor under Article 15 of the Rome Statute of what are known as the proprietary motor powers of the prosecutor to independently investigate events in a state party with a view to opening an investigation. Now, we'll start with Sudan. We all know, anybody who reads the newspapers and watches the movies, anybody who likes listening to Angelina Jolie or Brad Pitt, wouldn't have failed to realize the terrible unfolding events in Sudan. What can't be denied is that there was massive displacement of people and an awful lot of suffering. But what is interesting is the Sudan situation represented the first occasion, only 3 years old at this time, in 2005, 3 years after the Rome Statute came into force. The Security Council tipped its toes and its foot and maybe immersed itself into the waters of the ICC by referring the Sudan situation to the International Criminal Court. Now, what's interesting, one of the things that is interesting of this referral is that it wasn't unanimous. It was passed 11 votes to 4, and there were 4 important abstentions. And the abstentions were from Algeria, Brazil, China, and the United States. China and the United States both abstained in part because they were of the view, the stated view, that justice should be local. The preference should be domestic trials and at the very least regional trials. And if one looks back at the statements that were made at the time of the adoption of 1593, the United States representative was unequivocal. Anne Woods Patterson was the permanent representative at the time that was acting in the Council. And she stated very clearly that the United States believes that a better mechanism would have been a hybrid tribunal. So not the ICC, a hybrid tribunal. One thinks of the Special Court for Sierra Leone, or the extraordinary chambers of the courts of Cambodia, or the special panels for East Timor. Because the United States representative stated, and I continue, it was important that the international community spoke with one voice in order to promote effective accountability. The United States continues to fundamentally object to the view that the court should be able to exercise jurisdiction over nationals, including government officials of states not party to the Rome Statute. So we have really the remarkable situation that the Security Council refers a situation to the court on the basis that that situation constitutes, under Chapter 7 of the Charter, a threat to international peace and security. And finding that there is temporal jurisdiction and geographical jurisdiction handcuffs the court from inquiring into any criminal conduct done by non-state party nationals. Of course, that's not the case in a normal ICC case. That's not the case if a country refers itself to the ICC, nor is it the case under Article 15. Then the usual measures of the Rome Statute come into play. And if a crime is committed in the territory, within the temporal and geographical scope, the court would have jurisdiction, even if the crime alleged is committed by a non-state party national. So really this was very much the Security Council kowtowing, to use a popular current expression, kowtowing to the demands of international politics and the concerns particularly of the United States of America. But these concerns were not without effect. Because if one looks at the representative of Algeria, an African state, also a Muslim state. The permanent representative of Algeria really put a clear warning sign to all state parties about where this could lead. Because this resolution was passed just before midnight. Just before midnight, on the 31st of March 2005. And the Security Council, acting in a quasi-judicial manner, which is the effect of referral, did they spend hours and weeks debating and discussing? Did they call for evidence? Did they analyse the situation in a manner that you'd expect even a magistrate in a local court to do, never mind an international court? Did they review it in a manner that a Home Secretary of a nation state would do when deciding deportation or other matters? They spent only 1 hour making a decision that would have crucial consequences, for good or for bad, for the people of Sudan and the region, and indeed for the continent as a whole. Because as we will see, the situation of Sudan and how the Security Council has dealt with it, and how the court itself has reacted to the referral, has had it caused a seismic shift in the relationships between the African Union and the ICC. And it's our view that that's not hyperbole. It is the reality of what one is looking at the moment. But the Algerian permanent representative at the time, who abstained, said this: the African Union is best placed to carry out this delicate undertaking of investigation because it could provide peace while also satisfying the need for justice. President Obasanjo had made a proposal, and this is important. Obasanjo, just a week before, had made a proposal on behalf of the African Union based on the need to secure peace without sacrificing the need for justice. And he continued, Abdullah Bali of Algeria, he continued, regrettably, for the sake of reconciliation, the Council had neither considered that proposal nor assessed its potential to enable its members to combat impunity. One could not claim to support the African Union while brushing aside its proposals without deigning even to consider them. At the eruption of the Darfur conflict, it had been none other than the African Union that had deployed its soldiers and begun negotiating the various complex issues involved. What was true of Sudan was true all over Africa, and Algeria regretted that for the sake of compromise at any cost, those who defended the principle of universal justice had, in fact, confirmed that even in the Council there was a double standard. So there we have it. The day the resolution was passed, moments later, the talk of double standards, of how international justice was dealing with, how the Security Council was dealing with international justice. Now, what's those concerns didn't stop on the 31st of March 2004. There were abstentions, there were not votes against, but the grumblings have increased and grown since that time. Now immediately, of course, there was no prohibition on the prosecutor, Luis Mourinho Ocampo, investigating, and he initially had access to Sudan, and he came up with various indictments, charges. President Omar al-Bashir, Haroun, Muhammad Ali, the top left, and also on the bottom three, rebels. So we see also, and we'll see it in the Kenya situation, we've seen it also in Yugoslavia to a different extent, almost not exactly an equivalency, but we see 3 rebels and we see 4 government members. Abu Ghada surrendered voluntarily to the court, and
I must disclose an interest. I represented the three individuals at the bottom, Abdullah Banda and Sahli Jerbo. Abu Gharda was acquitted on all counts. The case was not confirmed. But what's interesting is that that dealt with an attack over one day in which it said 20 AU individuals who were part of what was said to be a peacekeeping operation were killed. Now, Rod may touch upon this later about how the prosecutors assessed gravity, because 20 people were killed. The court, the prosecutor found they were of sufficiently grave nature as to give rise to jurisdiction. But when one also looks at the fact that the defense in that case alleged, in addition to all the deficiencies in the prosecution investigation, that the camp itself had lost its protection because they'd lost their essential ingredient of impartiality, and that the clear evidence from the prosecution was that the government of Sudan operatives were operating with the knowledge of the AU base commander to give coordinates for rebels and for civilians, and that led to their bombing. The fact that there's no jurisdiction to even investigate the conduct of non-AU, non-African state party personnel is a matter of concern, particularly when one peels or scratches just a little bit beneath the surface. You do hear many accounts that civilians were very badly treated, probably criminally mistreated by some of the AU personnel, including allegations of sexual favours for food, amounting potentially to rape and other matters. Now, I said that the murmurs of concern expressed by Algeria and other states, Brazil also expressed concern about the use of the court by the Security Council, and that suggested that the Council should be very concerned and very slow, maybe to use non-UN treaty bodies for purposes that they that really would enlarge the jurisdiction of the Security Council beyond that which perhaps was clear. But of course, since that time, what happened to President Omar al-Bashir? He famously said that he viewed the ICC and the prosecution statements and indictment very much like a mosquito in the ear of an elephant. So it's a nice, memorable phrase, but it certainly shows the ICC was an irritant. But he went around his duty as head of state all over Africa. He's in India at the moment, I believe. But things came to a head really when he came to South Africa in 2015. Now, he'd been to many other states before throughout the continent, West Africa and East Africa. He'd been everywhere. But what really focused minds is South Africa's, the way South Africa is viewed as a core member, a very important member, not only in Africa, but of the whole ICC creation. And when he came to South Africa, the fact that he wasn't arrested led to a cacophony of noise. And we see that just a short time later, a few months later, the pre-trial chamber required submissions from South Africa with a view to reporting it to the Assembly of State Parties for non-compliance. Now, a couple of matters come to mind. Samantha Power, the permanent representative of the United States, stated just in September 2015, in relation, in fact, to this proposal that France was banding around, that there should be an agreement, if not a resolution, amongst the P5 countries to suspend the use of their veto in cases where allegations were had been made of genocide under the 48 Convention or under the Rome Statute, amongst others. And what Samantha Power said is that, and I quote, "It's a Darwinian universe here. If a particular body reveals itself dysfunctional, then people are going to go elsewhere. It's a Darwinian universe here. If a particular body reveals itself dysfunctional, then people are going to go elsewhere." Now that was said with a view to, as you may recall, in relation to the downing of MH17 and other matters, there was a discussion having a bilateral Dutch tribunal, maybe with Malaysian involvement. Other options have been discussed in relation to Syria and elsewhere. So really she was focusing on her perceived deficiencies in the Council. But the principle, if it's good, is of general applicability. Because a mass of countries, no longer the so-called rogue states, the pariah countries of Zimbabwe or Sudan, who could be pejoratively called the usual suspects, but mainstream foundational states like South Africa are saying this court is not fit for purpose. Something's gone awry. It's not working as we envisaged. And if it's not working, people will go elsewhere. And we have seen that's exactly what the African Union is doing. They're moving step by step, or stride by stride, away from the Rome system to an African-focused approach. We saw it with the Hissan Habre case, where extraordinary chambers of the courts in Senegal to try Habre for offences alleged in Chad. We've seen it now in South Sudan. South Sudan, supported enormously by the so-called like-minded countries, didn't sign up to the Rome Statute. Why? Why not? Instead, they have preferred an African-focused tribunal, supported by the African Union, with African judges, with African prosecutors, with African staff, for Africans. And some view this as a threat to the ICC, but why should it be? Unless a court is in the business of building empires and expanding its reach to catch those that it wishes to catch, and to step away from those that it considers too hot to handle. Why should it be a concern? Because the principle of complementarity anyway is that states should get their own houses in order. So it seems to me to follow from that if a region wants to get its act together, that's a matter that should be welcomed, and those that believe in the ICC shouldn't view it as their toes being stepped on. But it's a sign that there's a loss of confidence in the Rome Statute. Well, it's led to other issues really that cannot be easily explained. If you look at the three individuals here, Bahagi Sabugada, but then the bottom two, after that case was dismissed, the prosecution failed to satisfy the judges that there was a case to come to trial. The prosecutor charged Abdullah Banda and Sahli Jabbar, who had taken up arms against the regime that the prosecutor said was committing crimes against humanity. Taking up arms against a regime that the Security Council had said constituted a threat to international peace and security. Now, what we did for the defence, amongst other things, is ask the courts to stay proceedings. Why did we ask them to stay proceedings? Because the defence couldn't set foot in Sudan. The defence couldn't enter Darfur. The defence couldn't conduct investigations. Come back. So, how are the basic foundations of a fair trial to be had simply by waving a magic wand in the Security Council in New York and saying, hey presto, we have jurisdiction? There are some it's not window dressing, it shouldn't be window dressing. There's some basic foundational requirements that are needed for a court to operate. And unlike Kosovo, where, against the will of Serbia, the United Nations put in place the United Nations mission in Kosovo, there was KFOR in place, and so in that environment, under that superarching administrative and military structure, the prosecution could do their work and the defense could do their work and fair trials could take place. But unlike that, in Sudan, defense couldn't even set foot. And the defense were asked to proceed and somehow manage, even though under Sudanese laws it constituted a criminal offence to cooperate with the court. So, I won't bore you with all the arguments. We have, the filings are public, or they're public versions of the filings. But we made an argument that those basic, essential prerequisites to a fair trial were absent. Without an investigation, without defence going there to the locus in quo and looking for witnesses and interviewing witnesses and doing site visits, you can't even get to the possibility of a fair trial. And it wasn't just the defence coming up with a clever idea to delay and cause difficulties, because we submitted briefs by no lesser figures as Justice Richard Goldstone, the first prosecutor of the ICTY and ICTR, who supported our position, Mr. William Fenrick, who was a member of the Commission of Experts before the ICTY was created, and later the senior legal advisor on all international issues and IHL issues in the Office of the Prosecutor of the ICTY, and Professor Mike Newton and others. And all of them said, in these circumstances, the only proper fair thing to do is stay proceedings until the conditions change. And what we were saying is, apart from the justice in the particular case, namely the rights of Mr. Banda and Mr. Gerbo, it would really properly put the ball back in the court of the Security Council, so to speak. Because it's easy for counsel and for politicians to get swayed by celebrities and the spotlight of attention focusing on perceived atrocities. And then to pass the buck and say, okay, ICC, deal with it, without arming the ICC with the basic tools to have a fair process. And where the ICC, I think, has failed is to say, I'm sorry, we're willing to do it if you do your part, which is to create an environment where fair trials are possible. And whilst the prosecution opposed our application to stay proceedings until the situation had changed, that's in 2012, those of you that follow the press would have perhaps seen Fatou Bensouda, the current prosecutor, in December 2014 when she addressed the Security Council, stating that she had no choice but to hibernate activities in Darfur. So it's a bit of a dramatic shift she called for in the Security Councils. But whether or not there's a reason for her to have opposed the stay and then to say she'd hibernate, whatever that means, we've woken up when the winter's over, what is the legal significance of that, God knows. But to understand all of that is rather difficult. I'm told by Rod I'm nattering on a bit because I have quite a bit to cover. In relation to South Africa, the security, you saw here the pre-trial chamber told South African, report why you're not in non-compliance. But I think African states are much more willing to have adversarial and robust positions with the ICC to assert their sovereignty. And the days when perhaps they'd be expected just to do what like-minded countries think, perhaps are past. Because on the slide when it comes up, you'll see that just last month, in October 2015, this was the response of the Executive Council of the African National Congress. It's not to back down. It's to say very clearly, and really to build upon the concerns that the permanent representative of Angola said almost 10 years before. The ICC has lost its direction, it's unfair, and the Executive Council has resolved that South Africa withdraw. Well, South Africa's not alone, because Uganda, Museveni has said the same thing. The parliamentarians of Kenya have passed a vote to withdraw from their own statute. Rwanda and Paul Kagame have made very strident comments against the court. So, unless those individuals who believe in an effective ICC, that it does have a place and a part to play in the international legal order, that it is needed because the goal of accountability is one that no right-minded person could ignore, then they do need to have some regard to state parties. Libya, very quickly, was a similar situation. It was a referral by the Council. We saw very quickly after the warrants, after the referral of Resolution 1970, very shortly after that, Gaddafi was lynched and then tortured, sodomized and killed. And we saw Saif Gaddafi in custody by rebels in Zintan. Senussi transferred from outside of Libya. Money was paid. And we're left with two accused, Senussi that Rod will talk about, and Saif Gaddafi. Now, what was interesting when you compare it with the situation I'll deal with next, which is Kenya, is how did the court deal with this? Did the court say, obviously, Libya didn't have a well-known, well-recognized system of international justice, or even basic justice that would comply with regional standards. It wasn't known for having an independent judiciary. Libya wasn't known for having the best laws. It didn't have laws, for example, that implemented the obligations in their own statute. It wasn't even a state party. But unlike with Kenya, that we'll come to very briefly, the sound music from the main international actors was very much let these individuals be tried domestically. It wasn't saying not a cat and hell's chance. Any person with a bit of common sense will realize Libya is not able at the moment, even if it was willing, to conduct trials in accordance with international human rights standards, and Rod will touch upon what that means and the relevance of that when he speaks. But really it's a matter for Libya. We don't want to delve too deeply. Well, why was this the approach in Libya? When Kenya made an admissibility challenge, and I think Rod acted, I was representing the accused in that case, and Rod was representing the government of the Republic, the court really said, despite the fact there was implementing legislation, incorporating the obligations under their own statute, despite the fact there was a well-known judiciary, well-versed in the common law and international law, and there'd been international engagement at so many levels of the United Nations over so many years, despite the fact that individuals had been tried, albeit from a bottoms-up approach, the court said, no, unless you charge the same individuals for the same crimes, we're not going to be satisfied. We're going to keep jurisdiction. And the result of that, Rapp says the same thing, Stephen Rapp. Preference for the national system. So that was the sound music from everywhere, despite all the human rights reports that are there. But the result of it, what is the result of this refusal to have a bottoms-up investigation? Because that's what Kenya was doing. That's why Kenya said, give us time. We have the courts, we're doing it, maybe not as fast as you want, but we have to follow the evidence. And this was despite the fact Kenya told the ICC, please give us the evidence, and we'll use that to launch our own investigations. And the ICC said, no, we're not going to. The prosecution said, no, I'm not sharing my evidence with you, albeit they were willing to bend over backwards and assist the Libyans with reviewing their own evidence. So again, is it double standards, or is there some principle that can be discerned? The result of naming and shaming was the 15th of December 2010, just the day of the court recess, perhaps as a Christmas present to the people of Kenya. The soon-to-be-departed Louis Moreno Ocampo, some thought, very keen to name individuals in a very high-profile case before his tenure expired, named these 6 individuals: Joshua Sang, General Ali, William Ruto, Koski Mathara, and Kenyatta. Now, these were named really without investigations. And this is not, again, the rhetoric of defense. So, declared interest, I've represented 2 of those individuals, Ambassador Mathara in the second case, and William Ruto, the Deputy President, in the first case. It's not the rhetoric of defense counsel saying they're not investigations, because no less a person than really one of the stalwart of the court, one of the most respected judges of the court, Judge Christine van Wijngaard, a well-known Belgian academic, sat with distinction in the Yugoslav tribunal, had sat in very important cases like the Rodney case at the ICJ as a judge ad hoc, and ICC judge, has stated in decisions in the Kenya case that the prosecution's approach had been negligent. They had not investigated properly. The result is, out of these 6, 4 have been dismissed without coming to trial. Ambassador Mathara, and the 3 others were not confirmed. Ambassador Mathara was withdrawn after confirmation. So 2 are left: the Deputy President, William Ruto, and Joshua Arap Sang. Now, one of the things that defense has to grapple with is, from the defense perspective, is when the prosecution fall into difficulties. And we've seen this in the Limai case, we've seen it in the Haradinai case, we've seen it, I think, in every case I can think of. They explain it by way of interference, political pressures. Now, one thing is certain: international criminal justice works in polarized environments. International criminal justice deals with post-conflict situations where people are divided politically or racially or by ethnicity, very often. And it's a matter of very often obvious and, to an extent, very legitimate debate about what happens in these courts. We saw in the United States there was a criminal investigation against President Clinton, albeit for impeachment, the Monica Lewinsky saga. And America was polarized. And you used to read any commentary at the time, and there were almost fights in pubs and all kinds of things, in which the country was divided between those that said, Clinton was the Antichrist, and those that say Starr, the special prosecutor, was on a witch hunt and was the devil incarnate. But that kind of environment, whilst a criminal inquiry was underway, wasn't said to reflect badly on the United States of America. What happens in countries like Kosovo and elsewhere, where people have strong views, and if you believe in freedom of the press, people do debate it. Sometimes they go above board, they go a bit over, they don't keep the sense of balance. There's a vigorous discussion. But what the prosecution tends to do, sometimes rightly and very often wrongly, is to blame evidential deficiencies, investigative shortcomings, upon what we call here extraneous factors, the fog of confusion, the allegation of witness interference. And we have filed just recently, in the case of the Deputy President, our no case to answer. And we make that very clearly at that point, that it's not, this disintegration of a case has not been because of these extraneous factors, but because of fundamental failings that the OTP have run into, basically by taking in a domestic processes inquiry and taking it for the truth of its content without investigation and inquiry. And that kind of shabby, shortcut, less than diligent, what Christine van Wijngaard had called negligent investigation, really has a much wider consequence to international criminal justice than the fate of William Ruto or Mr. Joshua Arap Sang, but goes to the foundations of international criminal justice. The Americans said one of the reasons why they refused to sign the Rome Statute is because of prosecutorial overreach. In these years, what is needed is a prosecutor that will be guided by the evidence, that will conduct proper investigations, And what is interesting now is after the Kenya case has started, just last year, the prosecutor announced a new strategy paper. Some may say it's very similar to what Kenya was trying to do, a bottoms-up approach. Start with the direct perpetrators, like happened in Tadic in the ICTY, and then build up and see how far you go. But at every stage, you have strong foundations. That's the prosecutor's new strategy. Very similar, you may think, to what Kenya had said it was trying to do when it said the case should not be admissible, because it was trying to go for a bottom-up approach. Well, there's lots more to say. I think I've taken my allocation of time. Hopefully there'll be time for questions. But they're my brief comments for the moment. Some of the controversies that arise in the ICC that implicate both the ICC itself and its place in international legal order and its relationship with the United Nations itself. Thank you very much.
Thank you very much. We approach international justice today, I think, at a momentous time. Never before has it been under so much scrutiny. We only have to think of the events in Syria. Everyone is saying, well, how come no one is being investigated and prosecuted for what's happening there? But then across the sea down in Africa, countries saying, well, how come you are picking only on us? We saw the events in South Africa where it was determined unilaterally that the president of Sudan didn't have immunity. His immunity is gone. He can be arrested. Is that wrong? Is that right? Huge debates going on about that. So much so that South Africa has said it's going to withdraw from the ICC. Can you imagine that? Can you imagine an ICC after a country like South Africa decided to withdraw from it, and what the effects of that would be? If that's not enough for you, well, Palestine is now signed up. So the prosecutor has the Middle East in her investigation sites. If that's not enough for you, Russia is now potentially going to be investigated, with Georgia and the Ukraine as countries over which the prosecutor has jurisdiction. She says she's going to open an investigation in relation to Georgia. And I felt I had to mention Timbuktu, of all places in the world. We have a case from Timbuktu now in relation to the destruction of cultural property there. But I wanted to start, having said that, with what's happening right on our doorstep, Egypt. You probably would have heard that the current president of the military regime in Egypt, Sisi, is visiting London at the moment. In fact, he'll be meeting with the Prime Minister tomorrow. Many groupings are saying that he should be arrested, or others in his entourage should be arrested. The immediate question arises over, doesn't he have immunity? Well, I said earlier on, many people were asserting that the president of Sudan doesn't have immunity. Well, how come Sisi suddenly has immunity? Is a question that is being debated. I raise this because what I want to emphasize, and I think that's what Karim has been emphasizing all the way through, is that there are very different approaches that are taken from time to time with international cases. It's very useful, and we're only going to be able to do it briefly today, to compare and contrast the differences in approaches that are taken. Differences that may be justified politically, arguably not, but in politics you can get away with it. In law you can't. You have to be consistent. If the rule of law is to mean anything, then you have to at least try to be consistent. It might be very difficult, we accept at the moment, to be consistent all the way through, but you have to be seen to be trying. And that's the question I want to pose today, is whether when we look at some of these cases, and they're going to have to be done in summary form, but when you look at them, do you think there is a real effort being made to develop a consistent legal principle and approach, which will ultimately allow these institutions to flourish, and as Karim mentioned, will ultimately encourage or make it very difficult for countries like the US, Russia and China not to join, they're never going to join if there are massive inconsistencies, if it seems like it's just being made up as you go along. So Egypt is a very good example. I have an interest in many of these cases. I have to say that from the outset, and you can discuss that afterwards. I'm quite happy to hear different views on this. But where this all started as a way of background is Dr. Mohamed Morsi was democratically elected as the first president of Egypt in June 2014. This was after the Arab Spring. Everyone thought we were on a new wave of democracy. He was accepted internationally. You see William Hague over there visiting in London, much like Sisi is doing at the moment. But in July 2013, he was removed from power in what the African Union itself termed to be an unlawful coup, President Sisi taking his place. And what followed wasn't a transition to democracy, as many people had expected from the rhetoric of Sisi, but rather the imprisonment of Morsi, of 40,000 other persons, not only from his party, but a range of groupings, liberal, secular types, all of those who opposed the coup as it had taken place, and many people being put on trial, with thousands of death sentences being imposed on a mass level, and some executions having taken place already. There were widespread protests against this in the months that followed, and you will all recall in August of 2013 the Rabah Square demonstrations and the massacres that followed, with at least 1,000 protesters being killed on just one day, many killed thereafter, and arrests that took place. Now, that is all well catalogued. It has been taken up in many legal actions. And we're in a situation today where that is why when somebody like Sisi is visiting London, there are calls for his arrest and for action to be taken. I jumped ahead to the next slide, but what I find interesting, just to go back to the contrast, is look here at what David Cameron said about President Assad. He said that he can't be part of Syria's future. He has butchered his own people. He is one of the great recruiting sergeants for ISIL. Many people argue that Sisi is exactly the same, a recruiting sergeant for ISIS. But Cameron made it very clear that he wouldn't welcome somebody like President Assad. He wouldn't deal with him because he butchered his own people. You looked at the facts I showed earlier. What is the difference between Sisi and Assad? Why does he deal with him and give him red carpet treatment when he's done very much the same thing? Is that a tension that can be justified politically? But what about legally? Can you allow for people like Assad to be arrested, or the president of Sudan, but not Sisi? And how do you justify that as a matter of the rule of law? I'm going to move rapidly on to the next case study, and that is the one that I mentioned earlier concerning Israel and Palestine. I've got up here one part of that, which is the attack on the Gaza Freedom Flotilla, which the ICC has jurisdiction over. It's part of the wider conflict, which has now been referred to her by Palestine. Well, Palestine hasn't formally referred, but they've signed a declaration going back to Operation Protective Edge of last year. So on that basis, the prosecutor has opened what we call a preliminary examination. Now, here are immediate concerns which I want to highlight, and once again can be used to contrast with other cases. In Libya, Karim mentioned, Security Council resolution, almost immediate opening of an investigation and indictments brought out. I'll come on after that to say, well, nothing happened thereafter because the political situation arguably changed. But in the case of the Israel-Palestine conflict, how long do we think the prosecution is going to have a preliminary examination open in comparison to countries like Libya, where the political pressure was on to bring charges very quickly? We have seen in countries like those in South America, she's kept preliminary examinations open for 6, 7, 8 years. My concern is exactly the same could happen, like happened in relation to the Gaza Freedom Flotilla, where it took her over 2 years to decide whether to open an investigation or not. She eventually did decide not to open an investigation, which I'll go on to now. But the question comes up in relation to Israel and Gaza, how long she could potentially bury that case through an extended preliminary examination. Also, something else I think to bear in mind, which also raises some of the contrasts, is whether or not she may focus only on one side, the Palestinian side, which is cooperating with her. Israel is not at the moment. And we've seen in other situations, although, as Karim highlighted, in some situations she's looked to balance, but in others not. She's only focused on one side of the conflict, like in Uganda, like in the Congo, like in the Central African Republic. And what justifies looking only at one side in certain situations, but in others looking to balance it out? My essential point I want to make here, in addition to those concerns though, is that she needn't wait at the moment, because in relation to this case, the Mavi Marmara case, she in fact has jurisdiction. Just a bit of background, there was a flotilla consisting of 7 ships that sought to break the Gaza blockade and deliver humanitarian aid to Gaza in May 2010. It was attacked here, some pictures from the attack. 10 people were tragically killed, hundreds injured and tortured and arrested thereafter. The prosecutor went on to find that war crimes were committed, but she said the case wasn't serious enough to open a full investigation. What happened thereafter was that that decision was challenged, and in a watershed decision, some may think, the trial chamber, 2-1, decided that she got it wrong and asked her to reconsider her decision. She hasn't done that. She's in fact appealed this decision, which is currently before the appeals chamber. And we're in a hiatus where no investigation is going on. So there is a situation, we say, based on what the judges have indicated as well, that she could investigate in relation to that situation, but is dragging her feet. The problem with the system as it's set up, whether you think it's a good or a bad system, is that it all lies in the hands of the prosecutor as to how long a preliminary examination takes, whether she will open an investigation, what the targets are. The judges, as you can see here, can say you've got it wrong, but it's not their decision at the end of the day. She controls who comes before the ICC. The judges don't get involved at all. Arguably, that's something that should be reformed. It's a topic probably for another day. But arguably, the judges should have more say in determining which cases should go ahead and those which shouldn't. Sailing quickly across further east now to Sri Lanka, and here to a country, a fascinating case study, once again is going to throw a whole range of contradictions, where at the beginning, everyone was saying in relation to Sri Lanka and the war that took place there. It was a 25-year war, especially at the end there were allegations of mass atrocities being committed when the government forces overran the rebel forces. Calls were made initially, we have to have international trials. The UN Human Rights Council was engaged and they started looking into the matter. We've ended up now, which I'll come on to, following a change of government with a backtracking on that, particularly from the US. It was the US initially that were driving trials, and now they're saying, actually, we needn't have trials, and a resolution adopted, sponsored jointly with the US, saying, in fact, truth-seeking mechanisms, a lot of emphasis on that, may be sufficient. It's not a fundamental shift, it's more nuanced, but many people looking at this say it's primarily because the previous government had turned its back on the UN and the US and looked towards China, and there was a major demand made for trials. When that changed with the new president coming in who looked more west, all of a sudden we saw softening And you get language like this, whereas the previous government was saying we do not want any foreigners involved, and the current government has to say that as well. The US initially saying, no, you're going to have foreigners involved. You get language in the end, and also affirms in this regard the importance of the participation in a Sri Lankan judicial mechanism, including the Special Counsel's Office of Commonwealth and Foreign Judges and Defence Lawyers. What does that mean? It certainly doesn't say you've got to have an international tribunal, does it? But it also doesn't look like it's a total U-turn. So a more fudged situation now, arguably because of the change in circumstances. President Rajapaksa on the left there, who was the former president, very opposed to the US and international involvement. Saracena on the right has reached out to the West and has managed to negotiate this settlement where it will essentially now be for the Sri Lankans to determine how they will go ahead with it. With I would read it as very little international involvement. So a complete U-turn, no involvement of the ICC at all. Much more of an emphasis on this, on truth commissions. This was what Desmond Tutu said about South Africa after apartheid. He said, that there would have been no negotiated settlement, and so no new democratic South Africa had the negotiators on one side insisted that all the perpetrators would be brought to trial. While the Allies could pack up and go home after Nuremberg, we in South Africa had to live with one another. Well, that sounds like a familiar situation for all conflicts, doesn't it? People have to learn to get on with themselves afterwards. That's exactly what the Sri Lankans were saying, and they've relied on the South African Truth Commission model and used people from South Africa to justify having their own internal mechanisms where you don't put everyone on trial and divide the nation again. And interestingly, the slides should come up. That's why I usually don't use slides. Yeah. Slides should come up. But David Sheffer, former United Nations Ambassador at Large, has said in relation to Assad, well, why don't we just give him immunity and allow him to leave? That will bring peace. There's no need to have trials. There it is there. For a second. So that shows that there's no uniformity of approach on this. I want to lastly move on to look at Libya, because I think it is a real test for the universality of human rights. Is there anything that can be done or not?
No, I don't think we can do anything. We sadly have to live with that.
Okay. Right. Abdullah al-Sanusi, one of the most hated people in the world, responsible for all of these things allegedly, bringing down this aeroplane, Lockerbie, Abu Salim massacre, and then charged at the ICC after the Arab Spring. So arguably somebody who, and I've heard this murmured in corridors, well, you know, does he really have any human rights? Well, why does he need to have a fair trial? A trial in Libya, according to Libyan standards, should be enough. In fact, that's been said to some extent publicly. This is the uprising that he's charged for at the ICC. Very rapid indictments brought out, no mucking around like in other situations that are potentially more sensitive. A short list there of the allegations about his abuse in detention. Beatings, torture, confessions, family not able to see him, no lawyers, his lawyer was shot in the leg trying to see him, not able to present a defense at trial, a litany. And I'm not making these things up. These have been recorded very widely. And I don't think you can find anyone, in fact, who says that he has been given a fair trial. They wouldn't say that publicly. They just turn a blind eye to what has happened. this is one of the photographs that shows him coming out before his trial, which was used in our case to show that he potentially had been beaten beforehand. What did the ICC decide? Okay, that's a summary of it there. Okay, they decided, and I think you're going to guess that I don't think very much of this decision. They decided in essence 3 things. One, the accused, he has no right to participate in admissibility proceedings. They said, we gave him lawyers as a courtesy, but in fact he has no right to participate. Secondly, they said the ICC is not a human rights court. We're not here to uphold human rights in the classic sense. Only if there are the most egregious human rights violations may we find that we should take over the case. Which they said in this case hadn't existed, therefore he could be tried in Libya. And then lastly they said, even though this was going on over a period of time, they couldn't keep looking at evidence as it was coming in. No new evidence. What the prosecutor could do was she could apply to review the case later on, which she hasn't done. So in many senses they have set the bar very low. They've said countries that conduct these kinds of trials can continue to do so, and we're not going to ask the ICC to get involved. In the case of Saif Gaddafi, for some reason, yes, his case should come to us, but not Abdullah al-Sanusi and the others. How that makes any sense, I've yet to fathom. Even the government, which has fled to Tobruk, so this is the government that was officially recognized, has said this is an unfair trial and that it should not be allowed to stand up. What I did have was one last slide, which is quite an interesting one. I don't know if I can get it now. Anyway, it was a picture of the world as it existed 300 million years ago. It was in fact one world, completely united, my code, except there were no human beings on it at that stage. But I put it up as a slide to provoke our thinking. If we had, there it is, Pangea. The tectonic plates are moving. I put it up to make the point that if we did exist in that kind of environment, where there was much more integration, and we were able to have one centralized political system, many of these problems may not arise. The key issue comes from the fact that there is no central parliament or political body. It's concentrated partially in the Security Council and in other mechanisms. And it's impossible, therefore, for these political interests all to be married at any one point. That can be understood at the international political level. But the big question is whether, as lawyers, as legal institutions, we can tolerate that and allow for those differences so openly to appear, as I think we've tried to show, without any proper explanation. It will affect, and is already affecting, the legitimacy and integrity of these institutions. And as much as we talk about international cooperation and integration, and I had some quotes from the president of the ICC, it for me remains at an entirely rhetorical level, unless through these practical cases we could show that we are genuinely endeavoring to develop a principled rule of law that will apply and give effect to the equality of all states and the citizens of those states. Thanks. I'm sorry about that. We did try, and hopefully it nevertheless got the message across.
Thank you so much. I apologize for the attempt by the system to destroy international justice. I think we do have a couple of minutes left for questions, and I'm rather sure there's going to be quite a lot of them. We might not be able to answer all of them, but we have some minutes. Yes?
Oh, I had a question to Mr. Khan in relation to Kenya. You provide a very interesting, really general overview about the International Criminal Court. But in relation to Kenya, obviously it was the Waki Commission, the Kenyan Commission initially, that really provided a report that subsequently Kofi Annan used to give this envelope to the chief prosecutor with the names of the people he believed were most involved really in the atrocities. So I think that initially really there was a lot of enthusiasm as well. Even in Kenya you had civil society that was very, very happy about this. You had pop stars who were writing songs about Moreno Ocampo saying how great he was. And I think it's more really subsequently where the way that the investigations were carried out and issues, as you raised, about really how serious and how thorough the investigations have been and whether they rely too much on third parties, that has been really the issue, and the recounting of witnesses as well, of course, has led to it. But I think that initially, at least, there was this enthusiasm also as well present in Kenya, and this is kind of the general view as well that one tends to overall have about the ICC, is that civil society is very keen on the ICC, and that possibly, one would get the impression that a number of political leaders, political ruling elites are not necessarily that keen on it anymore. Once we kind of accept that the prosecutor is also going to investigate state actions rather than just in the actions of the political opposition, like Bemba or others.
I'm not sure what the question was, but I agree with you that there was enthusiasm in Kenya. My current client, the Deputy President, in fact, was well known in Kenya saying, let's not be vague, go to The Hague.
Yeah.
That was the mantra that was being repeated. A previous client, Ambassador Mathara, was a permanent representative during the PrepComs, and he supported the ICC. And there was a view in Africa that it's international, it will be better because it's international. Maybe it was a hope, maybe it derives from a lot of historical reasons that outside is better than what we have inside. But certainly there's been a massive disappointment, because if one took a Gallup poll in Kenya today about how they view the ICC, stay away from the government and those in power, people would say it has not served them well. In fact, victims themselves have, and there's public reports about it, have heavily criticised the prosecution for not getting to the level of the issue. And we said in our opening, just out of interest, that what these trials will show is not who's responsible, but who's not. And it comes down to why. Yes, it was wacky. There was a domestic commission of inquiry, and an envelope was given, and boxes came to the prosecutor's office. But what had been the hopes of many was that those reports would not be taken at face value, but would be independently reviewed and scrutinised. And that hasn't happened. And in fact, we have, it's in the press now, we have people in Kenya who've come out with what we all know, we have evidence for it, that in the aftermath of the post-election violence, there was a winner and a loser. The winning side, the government of President Kibaki, were accused of stealing the elections. On the other side, there was a lot of noise against the government. To quieten that noise, or to have some kind of equivalency in the media, there was an orchestrated attempt through domestic processes, there's something called Kriegler for the elections and Waki for the violence, to really put your men, because we're largely men, but men and a few women, into these commissions to give evidence against the other side. And that's happened. That was a domestic process. ICC wasn't even thought of at the time. It was, countries in transition, the coalition government, and everybody's pointing at the other. What an international prosecution has to do is to review it. And when they don't review it, you get 4 failings out of 6, and the jury is out, so to speak, on the next 2. It could be a clean sweep, 6 out of 6, we hope. Those of us that know the case. So you get into these problems where you go in what I call it as legal tourists. We can't get off the plane and think Africa is all the same. It's a massive continent. North, East Africa and West Africa are very different. North and South are very different. Never mind, Kenyan is very different from a Ugandan or Tanzania. You have to have that humility to understand the history, the culture, the political environment, and don't go in with your baggage thinking somehow it's not as sophisticated as we used to in Western countries, because sometimes, whilst development may not be at that stage, the political intrigue and the political sophistication amongst the guy in the street beats anything we have in, for example, in the United Kingdom. So I think unless you have that humility and that willingness, you can get it wrong. You're going to get it wrong.
But just to say, but you make a good point that often suspects themselves can be complicit, for want of a better word, in the manipulation and inconsistencies that result. I used Libya as an example. Without making light of the situation, I can't imagine too many of those who are accused now would be embracing the ICC as much as they are doing now when they are in custody in Libya.
I mean, that's a very good point, because in relation to both to Sanusi and Saif, and in fact, the de facto, de jure Prime Minister, Dr. Baghdadi, all three of them approached the ICC really as a life raft, because they realized they would have a chance of a fair trial in The Hague, whereas there was a certainty of a death sentence if they stayed where they were. And that shows accused really seeing ICC, when you compare it with the gallows, as a real option where you have a fair shot at actually testing the evidence.
Thank you for the lecturers. My question is simple. I'm a pastor. I'm now studying law. I've been a pastor for 30 years. My family comes from Nigeria, and I've worked globally in the ministry as a Christian minister. And before that, I worked as a journalist. And my impression of the International Criminal Court is that it's another institution to enforce Westernism on the non-Western world. That you've got Westphalian created states in Africa that have not been resolved. The issues of nation states, the cartography of Africa is chaos. People sat in Whitehall in Paris and decided to lump different people into nation states. Until these are resolved and the economical development of Africa and Asia is resolved, and the religious nuances that make up these societies, the International Criminal Court for me is too neat, too tidy, too Western, and too triumphalist. So my question is, how do you make it a court of last refuge for every nation, and not just for third world nations?
I think that we all know the history of Africa, but I take the view, certainly knowing a little bit about Islamic law and the Western law and all the rest of it, that the law, black letter law, is universal. The values that the ICC seeks to uphold are applicable in the Muslim world, in the African continent, and in Europe. And there can be a big debate about that, about Cyrus the Great and the Genesis of Islam and all the rest of it. Why is there this debate at the moment? It's because of what the permanent representative of Algeria called double standards, what Rod would call, what we would call inconsistency, in which it seems that the dictates of justice are malleable according to wider extraneous political realities. And the minute that happens, and you're dealing with a non-state party or dealing with another continent, questions have to be asked. Now, those questions can be answered, but they'll only be answered when you listen. And what tends to happen, talking about civil society, some are phenomenal, they're excellent, but it would be remiss to not think that some civil societies really milk the ICC because there's an awful lot of money. It's $1 billion business floating around some NGOs. Some do a wonderful job, some are in it perhaps for monetary considerations. And there needs to be a more selective analysis as to valid criticism and a deafness to sycophancy that is saying the project is the all and it's some kind of evangelical process, and that it's some heresy to say the emperor is half clothed, if not fully naked. And I think that honest debate is needed. And unfortunately, we get a situation where either you're completely for the project of the ICC and all it stands for, and if you say it's a great idea but it needs to improve, some might put in the waste paper basket of those that say it's all a colonial project. And I don't believe it's a colonial project. I think that's really, I don't subscribe to that. I don't think it's
a perception.
I don't think it's respectful of Africa. But these perceptions arise because of the duality of approach that seems to take place far too often. And that's the nettle that needs to be grasped, I think, by the court.
But I don't think we must underestimate the importance of having an international court. I was mentioning earlier, struck this week, Remembrance Week, looking at some of those pictures of the bombings in the Second World War, and just realizing how only 60 years ago we thought it was fine to do that, just fly over each other's cities and bomb children going to school. And that's all changed dramatically. That just simply wouldn't happen anymore. And part of that is because of the courts and law. And of course, law is still not implemented fully, but we've come a long way as a result of developing international justice. And we must try and use this court to to the same end. So if ever I'm approached, people asking as clients, should we get involved? I always say, yes, you've got to contest it and try and make it better and reform it from within. If you stay outside, then it's an open goal. You're never going to be able to try and change it. And of course, if you're in a sort of Nelson Mandela situation where you face an apartheid court and you say, I'm boycotting it, that's one thing. But I don't think it's that kind of court. It's one, you either are going to say, I boycott entirely, which some people have said, but I don't think that's the right approach. You've got to get stuck into it and make it work. And through all of these challenges, some of them we've been raising today, that's how it begins to change. Because ultimately, if you have justice on your side and you're fighting for those rights, it's very difficult for those institutions not to change in that direction. Otherwise, they just look hypocritical.
One final comment, which is that basically most of the crisis emanating from the old British Empire, the British Commonwealth, Sri Lanka, Libya, well, Libya was not part of the British Empire, Kenya, etc. They're rooted in the fact that you've gobbled different groups of people into one nation. And most of the conflict is rooted into tribal warfare and the control, the aspiration to control political power as a route for garnering economic wealth. So I'm saying that while the ICC is a credible effort, it should be commended as far as it goes, but there are issues that need to be addressed in Africa and Asia and the Middle East, which I think the ICC is not, with due respect to it, able to competently address in total.
Yes. See, it may be right, but sometimes I have friends, and when you reach 40 years of age or 50 years of age, you have a friend that starts blaming their lives on their parents. You start saying, get real. You're grown up now, and you must make decisions for yourself. And we all know the historical, the history of Africa, colonialism, warts and all. But I think Africa is sophisticated enough now as a continent that it's not an answer to simply say things because of what happened previously. There is a responsibility that is actually being grasped by African leadership now to do things and charter their own future, and this is part of that debate. Sorry, please.
I would just say that I think the problem with the ICC is more about, like you said, it's political, and it appears Western dominated. It's because a lot of the spheres of power are dominated by the West. But for us, in the context of Asia, we most of us from smaller Asian countries don't think anyone from more China, for example, responsible. So in that aspect, I think that, I can kind of agree that I think that probably there's some issues with colonialism, with double standards. But at the same time, I also feel like, we have powerful non-Western powers. I kind of see why the ICC is a valuable court for, let's say, smaller Asian countries versus more powerful countries. It's just that the Western world is
But I think that that's the big countries will come under enormous pressure to join if the ICC does it right all along. Where you have the kinds of problems emerging that really highlighting, it's going to be incredibly difficult to put the pressure on them and to embarrass them ultimately. Because there's only so long that you can keep dictating to others and staying out of it. Over time builds, and they'll have to join. But the key is for the court to do a good job now so that builds. At the moment, I think we're both saying, it's not in that position. And while it is weak like that, it becomes so much easier for countries to flout it and try and use it on the one hand for political reasons, but then also say to their own population, so you don't want to go there, we don't want to subject our generals to that kind of court. So much responsibility rests on the court. And I think part of the problem is that the current administration there is much too concerned sometimes about taking on controversial issues. They think that's what's going to anger America and China, and that the long-term survival of the court depends on appeasing them, staying away from controversial political situations. And in my view, that's exactly the wrong approach. It might mean that they can't go diving in, but they've got to show a commitment to do it. And as a prosecutor, you can investigate, you can gather evidence, and then leave it to the politicians, the Security Council, to decide. But you keep your integrity as a lawyer, that you've done a proper, impartial job. If you don't want to investigate Syria, or you don't want to go into the Middle East, it's up to you. But I'm ready here. I've investigated it properly. There's credible evidence for the record.
I think, sadly, we will have to break here for time. I found, as an internationalist, I find that we live with the hypocrisies of the Westphalian system. I like saying the Westphalian system because I'm from Westphalia. We live with those hypocrisies on a daily basis, the equality of state versus the Security Council, in equal states, both in the number of citizens and yet in power relationships. With the international criminal justice, I sometimes find it, coming from Germany, of course, slightly difficult, the claim that this is basically targeted solely at Africa, given that a lot in the history was actually international criminal law acting in Europe. Yet the charges are there, the inequality is there, and what you've made me remember is that maybe in international criminal justice, the inequality in an institution like the ICC weighs more profoundly than in other areas of international law where we can live with them more easily. And the other thing, the perspective of a practitioner saying, you go into those situations, into those countries, you investigate in those countries, and we have often said the legal systems are sometimes not developed enough to deal with those investigations, yet who are we to say, now we will send investigators there who are not from the culture, and they will do a better job. The practical difficulties are immense, and they work very well in an environment like Germany, where you had a defeated country, and they took over the state, and they could go and investigate everywhere. And the language capacity was there, the administrative capacity was there. Works in the ICTY because you have the chance to go in. But you reminded us, I think, that how difficult it can be in other situations, and I think there's a lot of work to do, and I'm happy to be able to talk to you and see some of those people who actually do the work. Thank you very much for being here. Thank you very much for talking to us. We hope you will come back soon. And next time, we promise that the audio system will work better. Thank you very much for coming. We have an overcapacity crowd. Thank you also for bearing with that. One of the disadvantages of London is space. There is none. Thank you very much.